Having just come in, good morning, your ladyships and my lords. I'll take as short as possible. In order not to repeat, I will be very brief. Arising from the questions asked by the court, I'd just like to put it on record that and of course, in particular, the very rapid submissions of my learned colleague, Mr. Mahat. Sometimes you miss exactly what he's saying, but I picked out that he did not at all mention how the system for the KIMS kit was converted to the provision of PDF. The tender document, and we have provided evidence of it, did provide that the KIMS kit would transmit a compressed color photograph image using a compression technique that is in compliance with JPEG. That requirement was never changed unless it was changed quietly, fraudulently, and with the sole intention of rigging the just concluded presidential election. My learned friend again, Mr. Mahat, challenged everybody that if there was a program that could convert a PDF document or could edit a PDF document, they would buy it. They would buy it. I suppose he meant the Iebc. I, at that point, did ask whether he's an employee of the Iebc, but I was assured he was not. I would like to state for the record that the software for editing a PDF document is available free of charge and can be downloaded by him or the Iebc. And we would request that millions of public money not be used to do this. But the programs that exist for editing a PDF document include Adobe Acrobat DC, Foxit PDF Editor, PDF Filler by AirSlate, PDF Element, Small PDF, Nitro PDF Productivity, Fine Reader PDF for Windows and Mac, Adobe PDF Pack. And I would also invite the court perhaps to try any one of them out. Staging, I just want to add that staging is admitted even by Iebc. So it's not, does not lie in the mouth of counsel belatedly briefed to deny that there was such a facility. Mr. Maina Wachira Nyaga, paragraph 2 of his affidavit, sworn and filed on 29th August 2022, confirms there was a middleware in the results transmission system. And this is also confirmed by one of our IT experts, Mr. Benson Wesonga, that there was indeed an attack from the position of man in the middle. At page the evidence we produced of the data analysis by George Njoroge in his affidavit sworn on 28th August 2022 and filed on the same day, pages 68-73 of his report, Mr. Njoroge says that the results from the results from the polling station was between the 9th and 14th of August tallied 137,000 times 137,847 times. On the 9th of August, 38,353. On the 10th, 35,000 times, 574. 11th, 16,291. 12th, 8,357. 13th August, 14,357. 4th August, 24,000 times, 897. This shows that numbers, the same numbers were being brought back into the system from 34s, new 34s. Otherwise, and trying to find the magic number that would give the first respondent the win. Finally, I would like to make a few comments on the just concluded exercise, the scrutiny exercise, and state that very shortly that despite the good intentions of the court, the servers were not opened. Unless, of course, there will be another opportunity for us to make a few comments. They will? Or then?
Stop any conversation about the report at this stage.
Okay.
We will allow you time to deal with the report.
Okay. I want to say that the evidence that has been presented by the petitioners shows a well-orchestrated and fraudulent scheme that was executed with military precision. Let me agree with my learned friend, Mr. Mahat, on the use of the word military. He says military grade, but I differ with him to say the rigging was executed with military precision, and given the evidence that has been availed, using expert, foreign, and I'm now using another military word, mercenaries engaged for that purpose. I am not surprised that none of those gentlemen I'm referring to as mercenaries have not sworn an affidavit. People like that disappear and leave the country to its own devices. By the grace of God, we have remained peaceful, and I pray that we continue to do so. And finally, I will yield the floor to my learned senior, Mr. James Ray.
Milady, Madam Chief Justice, we would like a clarification from the court whether the replies and responses relate to questions of law that have arisen from our presentation, or whether it is an opportunity for our learned colleagues to rehash their case afresh and to introduce new evidence.
We know what constitutes a rejoinder. It's a response to issues of law arising from the respondent's response. So just to remind Council, it was about responding to matters of law.
Madam Chief Justice, I also rise to take or to request a clarification. The court was treated to a so-called live demonstration. Shall we be given an opportunity? We don't require more than 3 or 4 minutes to indicate that what the court was shown is not true. Because otherwise, this image is now all over the country, a sensational image about forms with the names of people, whereas in truth, that is not correct. All that I would request, Madam Chief Justice, is an opportunity for rebuttal. On the basis that that is new evidence, it was never played. Those are not polling stations in the petition. It's totally new. It will be unfair for us to walk away without being given an opportunity to defend ourselves.
Unless the court walks away from the questions that the court asked, you asked for a demonstration of how the staging was done. It was a specific question. And similar questions were asked to our friends to the left. A lot of new material was brought in. We kept quiet because we knew these were questions from the court and that no evidence should be kept away from the court in the search for truth.
What we are doing, and then at the end of it, we'll consider, because we are also checking whether that is new evidence. Yes.
I thank you. I begin by thanking the court for giving me this opportunity to make my remarks as part of the rejoinder for the petitioner. My lords, when I used to be at Alliance High School, every year, Professor Giddu is very happy about me mentioning his school. When I used to be at Alliance High School, every year I took part in a school play. Most of the time they were Shakespearean plays. Macbeth, Julius Caesar, Much Ado About Nothing. Can I recover my 4 seconds? Yes, I was saying I acted in every school play for 6 years. And when I became a practitioner of law, I tended to have the habit, every time I would appear in court, to take some verse from those Shakespearean plays, be it a comedy or a tragedy. And one time, S.M. Otieno, from whom I learned a lot as a young man in the practice of criminal law, he told me when I took my seat, did you read the charge? Did you look at the statements? Did you analyze the elements or the ingredients of the offense? Always remember, as a lawyer, that oration is not good enough. Substance counts when you appear before the court of law. And I'm saying this because in 2017, when he had a similar petition before your lordships, some of the advocates who are in that petition, acting for the respondents when we presented our petition, said that what we presented before the court was a science fiction. And I'm not surprised that even at the beginning, and it's well covered in the media, that what we have presented before you is fiction. And because it is fiction, you had a lot of speeches which I think do not belong to a courtroom. They probably should have been delivered in some theater where people love poetry, like my learned friend, Professor Giddu Muigai, whom I know, having attended the same school as I did. We share a lot of things in common. We have presented before your lordships a petition based on averments which are contained in the petition. We have placed evidence before your lordships, and the petitioners did not ask the petition to be struck out. Instead, they filed volumes and volumes of affidavit evidence, and I've addressed you at length on matters relating to the petition. And yesterday, I remember when your lordships and my ladies asked questions to the respondents, my learned friend, Mr. Gidu Muigai, said those questions were difficult questions, but they are not as difficult as the questions which were directed against the petitioner. But having said that, there is an important point about this new constitution. And I'm so happy that your lordships and your ladyships, some members of this court were part of the process of drafting this constitution. And my lady Justice Njoki asked a question which was very pointed. Why did we create these commissions? Why did we create these independent offices and secure their tenure in the Constitution? And the answer is that we are dealing with an imperial executive. The commissions became an insurance policy for the protection of the sovereignty of the people. And if you look at Article 249, the commissions and independent offices are required to protect the sovereignty of the people. And what better tool to use in order to protect the sovereignty of the people than to have fair and free elections conducted by an independent body. And this constitution requires that the elections must be transparent, and they must be administered in a neutral, efficient, accurate, and accountable manner. I would have hoped that if the Electoral Commission was indeed carrying out an election that was free and fair, transparent, and accountable, they will be offering all the evidence, including what is in the servers, that this is what went on, this is the record, this is the return of the elections that were held on the 9th of August, 2022. I thought that we were making progress. Your lordships and my ladies, there was a time that we used to file petitions against even the President of the Republic of Kenya under the old constitution. And if you approach the Electoral Commission before you file the petition, you had access to election documents and election materials before filing the petition. And I did that so many times. My learned friend Firoz Norji will tell you, because I was a petitioner. And he filed such a petition. Now, to get information from the Electoral Commission, even after filing a petition and an election has been conducted, is like the road to hell. Because that's what it is. And in Article 249, the sovereign, who is the people of Kenya, require of the Electoral Commission as a state organ to secure the observance of democratic values and principles and promote constitutionalism. Not just in the conduct of the elections, but even the way it runs its affairs. They cannot pretend that they're conducting elections and valuing and securing the principles of democracy as contained in Article 10 of the Constitution, and yet within the body itself, they don't value these principles that are not discretionary. Every state organ, every person is required to act in accordance with Article 10. What does the chairperson of the Electoral Commission do in the circumstances, not only of this case, but even in previous occasions? In the Electoral Commission, instead of having a commission of 7 commissioners, and you have seen the factionalism here, you have a triumvirate, you have a trioca that is moving together all the time with the secretary of the commission. This is not what the Constitution desired or contemplated. If you look at Article 88 of the Constitution, the mandate of the Commission in relation to the supervision of elections and referenda, at the end of that Article 88, and I think this is important, Sub-Article 5, the Commission shall exercise the powers and perform its function in accordance with this Constitution and national legislation. So that where the chairperson comes before you and does not show conduct that is in consonance with the Constitution, is that a matter that this court can just gloss over? When the Constitution says in Article 2 that this Constitution is the supreme law of the Republic and binds all persons and all state organs, and no person may claim or exercise state authority except as authorized under this Constitution. And throughout that Article 88, the Constitution throughout talks about the Commission, except in 2 instances, one of them being the declaration of the results in a presidential election. So I urge my ladies and my lords that where there's been an infringement of the Constitution, however good the outcome, but there has been an infringement of the Constitution, because the Constitution says how we should conduct elections. It does not matter whether you get 10 million votes or 20 million votes. If you get it by murder and killing people, if you get it by falsifying documents, however the numbers you end up getting in an election, that would not be the kind of election contemplated under Article 81 of the Constitution. The process matters. And anything in violation of the Constitution, if you look at the Constitution broadly, any infringement of the Constitution, violation of the Constitution in relation to state officers, including the president, including members of commissions, any infringement of the Constitution normally would attract consequences of removal, impeachment, because it's a matter that this Constitution frowns on. And that's why I always appreciate the fact that this Constitution requires of citizens, every person has an obligation to respect, uphold, and defend this Constitution. This petition is in defense of the Constitution. Is in defense of the Constitution because there's an election that has taken place that is putting somebody in office, or is attempting to put somebody in office without meeting the requirements of the Constitution. Not only in terms of, not only quantitatively, in terms of votes, but also in terms of what the Constitution requires the conduct of elections to be like. And my learned senior, Mr. PR0TEST, referred to a football match. These days, football has many rules, and they keep on improving. However many goals you score, if it is from an offside position, whether you're Messi or Ronaldo, it will not count. It will not count. So I urge the court, and I am an optimist. I think we are doing very well in this republic. I think we have come from very far. And as one who has practiced in these courts when things were extremely difficult, I know we are making progress, a lot of progress. There were times to file a petition like this was not easy. And if you file it, serving that petition will be very difficult. And that is not just because of legislation and a new constitution. The courts had made an intervention many times to protect the people against those who govern them, particularly. I therefore invite your lordships that looking at the article dealing with leadership and integrity, what has been placed before you is not a matter that the court can frown on, gloss over. This court said in 2017 in the Raila petition that if the Electoral Commission comes before you with the same kind of infractions and transgressions, this court will not hesitate to take measures against the Commission and its leadership. That is in the Raila judgment of 2017. In 2013, this same commission, fortunately for the chairperson, he was not there at that time, despite the fact that that petition was not allowed, but the court was not amused by the going-ons in the Electoral Commission, and by dint of the comments that were made by the court at that time, at least a few people were taken to court, although that case is still going on. I think this court, and reading the Supreme Court Act, Section 3, together with Article 259 of the Constitution, which talks to how this Constitution should be interpreted, and more particularly when it says in a manner that promotes the values, the purposes, and principles of this Constitution, and contributes to good governance. So I urge this court, with all the humility, that although this is a petition basically under Article 140, as defenders and protectors of this Constitution, you, with respect, cannot allow what has happened at Iebc to go without some kind of action in the lines that was suggested by my learned senior, PR0TEST. Impunity must be punished. Impunity must be punished. And impunity unpunished breeds arrogance. And arrogance leads to arbitrary exercise of power. And without that being done, this commission, which has got the protection of the Constitution, without the court making some interventions, it still be a divided commission with a triumvirate that runs the affairs of a commission that is supposed to protect and defend the sovereignty of the people. And what I'm saying in a nutshell, that this election cannot pass on account of violation of the Constitution, even by the constitutional dictates how this commission should run its affairs. If they cannot conduct their affairs in the manner dictated by the Constitution, then how can they preside over an election and that election have some legitimacy to the people of Kenya and to the world? Secondly, and this would be my last point, that if you look at Article 138, sub-Article 4, and my learned friend Mr. Otiende addressed you on this, that requirement for a successful candidate getting 50% plus one of the votes cast is not an idle provision in the Constitution. It requires of the Commission to come with it before your Lordship seriously when there is contestation and put the numbers before you in rebuttal to the case that were put before you. My little friend, Mr. Mahat, who is also my very good friend, in his address, he was not talking about what the law requires or what the Constitution requires. He was saying, this is what we do. This is what the Kimskits do. There was no constitutional or legal foundation that he was resting his arguments. And therefore, yeah, my ladies and your lordships, I would ask the court to apply the provisions of the Constitution to the letter holistically and allow this petition and return this country and back to the people who are sovereign, and let a proper choice be made of the person who is going to lead Kenya in the next 5 years.